Good afternoon, everybody. My name is John Kamen, and just a little bit of background about myself. I was a journalist for 10 years, and the last 5 or 6 of those years I spent at Work Comp Central covering workers' compensation issues. And I also covered Congress as well. And anyway, when I passed the bar, I contacted Bradford and Barthel and wound up using that experience with Work Comp Central to become a workers' compensation defense attorney. And so with those years of covering the various state legislatures across the U.S., it just made sense to do a legislative webinar, and so that's how we got to today's presentation. If anybody wants to contact me, you see my phone number there and email address there. I'll be sure to give those out again at the end of the presentation as well. So let's take a look at today's agenda. First, we're going to start with bills that are already passed or still technically alive. Next, we'll cover failed bills that are likely to come up again. After that, we'll take a look at some regulations that were proposed by Senate Bill 863. Those include the home health care fee schedule, the proposed interpreter fee schedule, and the finalized copy service fee schedule. After that, we'll take a look at some of the recent developments in case law, such as the Ninth Circuit's decision in Angelotti. For those of you who do not know, that is the lien activation fee case. We will also take a look at the California Supreme Court's ruling in the South Coast framing case. And lastly, we'll take a look ahead at upcoming issues that the California Courts of Appeal will take a look at in the next few months. One thing I'm sure that many of you will be doing today during today's webinar is surfing the web. And if you happen to miss a piece of this webinar, or you want to look up something about a bill, check out that link at the California Legislator website. And basically at that link, you can plug in any bill that we've talked about today. You can look for other bills that interest you. It'll tell you all about their history, what committee it's in, any recent changes to that bill. I should also mention our friends at Work Comp Central. They do a great job of covering all the recent developments at the California legislature as well. And with all that being said, let's take a look at our first bill. That would be AB 1124. This is the formulary bill. And what this bill would do is it would create a committee to help the Division of Workers' Compensation create a formulary. And now formularies have been a smashing success for payers in Texas, Ohio, and Washington. For those of you who are unfamiliar with the term, a formulary is a list of drugs approved for various treatments. Another thing that this bill would require, it would require weaning or detoxification plans. And what those do is those slowly taper applicants off of addictive painkillers. For instance, Wisconsin recently adopted this. I should note that this bill has not been approved yet. It's still technically pending. And so let's talk a little bit about what formularies can and cannot do. In short, they can be inclusive or exclusive. In other words, a formulary may be a list of drugs that are okay to prescribe without pre-authorization, or in the alternative, a formulary may be a list of drugs that are not okay to prescribe without pre-authorization. Now, if California does choose to adopt Assembly Bill 1124, this new committee created by the bill would get to decide if the formulary is inclusive or exclusive. Now, the state of Texas adopted a formulary, and they actually implemented that a few years ago. That formulary has been proven to save payers hundreds of millions of dollars per year. Now, Texas's formulary is a list of drugs that do not require pre-authorization. And their list is based on drugs classified by ODG, or the Official Disability Guidelines. For those of you who don't know about ODG, ODG is the guideline of choice for a number of states across the U.S. It's very similar to the ACOM guidelines in my personal opinion. There are some differences between the two, though. But in general, they are kind of similar guidelines. So let's take a look at some examples of how the Texas formulary is applied. For instance, in Texas, codeine does not require pre-authorization. On the other hand, the fentanyl lollipop does require pre-authorization in Texas. Now, Washington is another state that has a formulary. Theirs is a few years older than Texas's formulary, and it is much stricter. And by stricter, I mean that it lists fewer opioids and fewer name-brand drugs. And one of the great things about a formulary is that it can promote the use of cheaper generic drugs as opposed to the name-brand drugs. Now, according to the California Workers' Compensation Institute, a Washington-style formulary would remove 96% of the name-brand drugs from the California system. That alone would be a huge cost saver, and the reason why is that name-brand drugs are often often significantly more expensive than the generic alternatives. As I said before, AB 1124 would require weaning off of potentially addictive drugs such as painkillers. And that alone in other states has been proven to promote conversations between doctors and patients about drug dangers. And this, just the fact that doctors are talking about this tends to lead them to prescribe less of these dangerous painkillers. So that's another good thing that would do. Now, CWCI, that great think tank in Northern California, they've established, they actually released a study showing that a formulary could save California payers $102 million to $420 million a year in pharmacy payments. And for those of you who want to check out that press release and check out their study, just click on that link below. And also the WCRI, the Workers' Compensation Research Institute, is another good think tank, and they estimated that California may reduce prescription drug spending by 14% with the Texas-like formulary. And there's a link to their study as well. Now, there are several things that we want to keep an eye out for if Assembly Bill 1124 does pass. First of all, who would be on that committee that creates this formulary? That could have big implications depending on where these people come from and what their special interests are. Secondly, what style of formulary would we have? Would it be a list of things that doctors can prescribe without pre-authorization, or a list of things that, or a list of drugs that doctors cannot prescribe? Third, we want to see if they address compound drugs. For many of you who deal with liens, compound drugs are obviously a big cost driver. On many of our lien cases, it seems like there's always some large compound bills on there. And personally, I believe that a formulary would be a great way to limit compound drugs that are often unnecessary. Lastly, we want to see how this committee treats name brand drugs and generic drugs. Personally, I would hope that they would encourage generic drugs just because they are so much less expensive, and at the end of the day, they are the same exact drug. Now, there are several problems that states like Texas saw with the formulary. For instance, some doctors at the outset simply try to ignore that there is a formulary. They go about prescribing banned drugs as if the formulary does not exist. For that reason, states can draft regulations that put teeth into the formulary. And what those teeth are that the doctor cannot get reimbursed for self-dispensed drugs. And so, in other words, those regs would make it more difficult to get reimbursed for drugs that are not listed in the formulary. Another big hurdle is that many of these doctors are simply very busy, and they don't have much time to learn about this list of thousands of drugs. So with that being said, if the state does go with the formulary, there needs to be a big education program, and we need to make it easy for doctors to learn about the formulary and what the rules are. The third issue is that a formulary could make it difficult for applicants who are the exception to the formulary rule. There will be cases where a drug that is not okay for 99% of the population is still needed by 1% of the population. And for those people, there has to be exceptions to the formulary rule. So that would be another issue that the DWC or the Formulary Committee would have to address. And lastly, speaking of regs, a formulary does require a number of new regs, and that could take the DWC a while to draft. In California and many other states as well, they do allow for comment periods, and often the comments can cause the DWC to see issues that they missed. And in short, that can lead to several different proposals of different regulations. So in short, I believe that the regulatory process might take 6 months. It might even take longer. It's hard to say at this point. And so let's look at the takeaways of AB 1124. Once again, this would create a committee to help the DWC create a formulary. The DWC would write the formulary into the California Code of Regulations. Now, the deadline for the committee to create this formulary would be December 31st, 2016. In other words, before January 2017. And lastly, this bill would mandate gradual detox plans for potentially addictive drugs. Now, one thing that I should note is that on Friday, Work Comp Central did run an interesting story with quotes from the California Labor Commissioner. And he was saying that he had some issues with this particular bill. Now, the sponsor of the bill, Assemblyman Perea, had likened recent negotiations on this bill to herding cats. In other words, he's got a lot of different people to talk to, and there is some late-hour talk on this bill. And so what, in short, what the California Labor Commissioner did say, though, he said that the DWC already has the authority to create its own formulary. And he also hinted at the fact that the DWC could actually start working on its own formulary before this bill even gets passed. So that is, in short, the DWC could come through with its own formulary before this committee even gets established. And that's all that just simply remains to be seen. We'll just have to wait and see what happens. Basically, the sponsor, Assemblyman Perea, he is talking to many parties, and this bill could still technically change. And one reason why that's important is that the lawmakers are currently on recess. They are not going to return until August 17th. When they do get back, they are going to be very focused on the budget. And so there could be more changes to this bill in late August, early September. I should note that the last day to pass the bill is on September 11th, 2015. So hopefully we'll know by then that this bill has been approved. Okay, well, let's take a look at the next bill then, and that would be AB 305. This is the gender bias PD bill. And what this bill would do is it would increase the max PD rating for a mastectomy from 5% PD to 16% PD. Now, the reasoning behind that increase is that the thought process is that the maximum PD value for a woman's breast should be equal to the PD value of a man's prostate. This particular bill has been quite popular, but because the state came out and said that it could cost the state quite a bit of money, it will get its own special hearing from the Senate Appropriations Committee after the budget is proposed. In other words, lawmakers want to have at least some idea of what the budget is looking like before they decide to pass bills that could cost the state some money. Now, AB 305 is backed by the California Applicant Attorneys Association. And according to employer lobbyists, this bill is likely to increase litigation, as in it would cause more disputes over impairment ratings. This bill is likely to have its greatest impact on first responders who are, of course, subject to the cancer presumptions. One thing that this bill reminds me of is of labor and cause efforts to pass legislation preventing apportionment based on race, gender, or nationality. A number of these bills have previously been vetoed by Governor Brown. I should also note that there is case law prohibiting apportionment to genetic makeup. Now, the most recent version of this bill prohibits apportionment to sexual harassment contemporaneous with psych disability. It also prohibits apportionment to pregnancy, menopause, or osteoporosis linked to menopause. So what are our takeaways of AB 305? It would increase the value of a mastectomy to 16% PD from its current value of 5% PD. It would have its greatest impact on first responders with cancer presumptions, and it would bar apportionment to pregnancy, menopause, osteoporosis related to menopause, and sexual harassment. If this bill is passed, it would apply to dates of injury after January 1st, 2016. And here we have AB 202. This is our next bill. It is the cheerleader bill. It was recently signed by Governor Brown, and it requires sports teams to classify cheerleaders as employees, and it makes them eligible for workers' compensation benefits. The reasoning behind this bill is that it arises from lawsuits alleging that NFL teams misclassified cheerleaders as independent contractors. So what would this bill do? It would require teams to pay minimum wage to cheerleaders. It would also require the teams to reimburse work and travel expenses. And lastly, the teams would have to provide workers' compensation benefits to the cheerleaders. This bill was signed into law by Governor Brown several weeks ago, so this one is already law. Next, let's take a quick look at AB 822. I like to refer to this one as the SIGA bill. And this is a short bill that was recently signed by the governor. And it states that a claim does not have to have a final order before an insolvent insurer's claim can be submitted to SIGA. This bill also creates a rule that applies to non-workers' compensation claims. For non-workers' comp claims, it creates a one-year statute of limitations to challenge SIGA's denial of a claim. Moving on to another bill, AB 1542. This bill is still alive. In fact, it has strong support. It sailed through the Assembly with a 79-0 vote, I believe. And so it's currently, it still has to make its way through the Senate, but I see this bill likely passing. What this bill would do is it would allow neuropsychologists to serve as QMEs. As many of you probably already know, the DWC recently proposed rules eliminating neuropsychology from the QME list. And that action effectively bars neuropsychs from being QMEs. Now, per the American Neuropsychiatric Association, neuropsychology is a subspecialty of clinical psychology. And so they typically get involved in cases where the applicant has symptoms like headaches, cognitive deficits, and issues regarding brain function. In short, these doctors study how brain and nervous system influence the applicant's behavior. So the takeaways from this bill is that it would allow neuropsychologists to act as QMEs, and it is likely to be approved by the Senate and the governor. It's already been approved by the Assembly. So I expect this one to become law in either late August or early September. Now let's move on to the trucker bill. And before we get into that, let me tell a quick trucker joke. So a trucker was stopped at a roadside diner, and he stops at the diner and he stops for lunch and orders a cheeseburger, coffee, and a slice of apple pie. As he's about to eat, three bikers walk in. The first biker walks up, grabs the trucker's cheeseburger, and takes a huge bite from it. The second biker walks up, and he walks over to the trucker's coffee, and he proceeds to drink his coffee. The third biker walks over and wolfs down the trucker's apple pie. Now, while all this is going on, the truck driver does not say a word, and he simply pays the waitress and leaves. As the waitress walks up, one of the motorcyclists growls, "That trucker, he ain't much of a man, is he?" And the waitress says, "Well, he's not much of a driver either. He just backed his 18-wheeler over 3 motorcycles." And so with that being said, let's take a quick look at AB 621. This trucker bill would allow port companies employing truckers to enter into agreements with the Department of Industrial Relations, and it would allow those companies to pay all wages and benefits owed to previously misclassified truckers. In exchange, port companies avoid statutory or civil penalties. So in other words, this bill would benefit both sides. In short, truckers who have been misclassified and are potentially owed wages and benefits, they get their money, and meanwhile their employers get to avoid potentially costly penalties. Now, where did AB 621 come from? It arose from successful misclassification suits. And we aren't just seeing those in California, we've also seen those in the federal courts in quite a few states. So the impact of this bill, it would not actually impact work comp too much, but in general, I believe this trend of lawsuits does. As we tend to see more rulings that truckers are employees and not independent contractors, these trucking companies are more likely to provide workers' compensation benefits to truckers. And so our takeaways from this bill is that it would impact prior trucker misclassifications. It also will not affect day-to-day workers' compensation very much. And this bill is also indicative of a potential trend for employers to declare truckers as employees and not as independent contractors as they have in the past. Moving on, let's take a look at another bill that is still alive, and that is AB 438. AB 438 is the translator bill, and this would require the DWC and the DIR to comply with a 1973 law requiring state agencies to provide materials from English into languages that more than 5% of the population speaks. Currently, more than 5% of the population speaks Spanish, so this bill would require the state government to translate its documents into Spanish. Now, the first versions of this bill had an Easter egg for applicants' attorneys in it. And what I mean by Easter egg is I'm referring to those hidden sections of DVDs where it's an incentive to buy that DVD. For example, if you buy a DVD of a Clint Eastwood movie, the Easter egg might be an additional interview with Clint Eastwood. So in this bill, the hidden Easter egg would have extended the statute of limitations by 1 year whenever the state failed to translate documents. And so, as you can imagine, if the state fails to translate documents, suddenly you have the statute of limitations on tens of thousands of claims being extended, and that could be a huge problem for payers. Thankfully, this Easter egg was pulled from the bill. So the most recent version of the bill no longer has that statute of limitations language. So our takeaways from this bill is that it would require California to translate forms into any language that 5% or more of the population speaks. Currently, that's Spanish. Lawmakers have removed that language regarding the statute of limitations that applicants' attorneys would have seized upon. So that's good, and I believe that this bill is likely to pass. Another bill that is still alive is Senate Bill 623. Now, this bill pertains to, in short, I like to call this bill the Uninsured Employer Who Employs Undocumented Immigrants Bill. And what Senate Bill 623 would do is it would prevent the UEF, or the Subsequent Injuries Fund, from denying benefits solely because of immigration status. So our takeaways from this bill: Senate Bill 623 might impact uninsured employers more by ensuring that the UEF pays benefits to undocumented workers. Why would an uninsured employer care about that? Well, the UEF recoups benefits it pays from uninsured employers. This could also lead to more subsequent injuries trust fund benefits, which helps employers willing to take a chance on hiring disabled workers. Now let's move into the dead bills. AB 1170. I like to call this one the Farmers Meet Obamacare bill. And this was a rather creative bill. It would have created the Workers Fund financed by assessments on farms. And what the Workers Fund would have paid for is it would have financed group health for both industrial and non-industrial injuries. One of the key takeaways from this bill is that had it been approved, it would have meant more group health care for agricultural workers. And as many of you know, we're starting to see more and more of these farm claims from the Central Valley being filed at boards in Los Angeles, Van Nuys, etc. And often these claims tend to have rather sketchy facts. Well, if these agricultural workers do have easy access to care, for both industrial and non-industrial injuries, it could mean that we see fewer work comp claims with these sketchy facts. So that would be good. That would actually be great for payers. So even though this bill died early on, I was actually rather surprised by that. And frankly, I think there's a decent chance we could see something like this next year. Now let's move on to another dead bill, Senate Bill 563. I know that many of you out there definitely did not like this bill. So I would like to refer to this bill as the bill that bars UR on final awards. And this bill would have barred UR, utilization review, on medical care specified by the judge in final awards. So for example, if a judge issued a final award stating that epidurals were necessary, UR could not deny epidurals. Now this bill did have an exception to that general rule. And that exception stated that if the MTUS or the ACOM guidelines disagree with the judge's decision, then the payer could do a quick utilization review, and if that review comes back as a denial, they could send that to IMR. If IMR agrees with that UR denial, that would lead the parties to have the applicant evaluated by an independent doctor. If that doctor recommends different treatment, the parties could stipulate to go with that different treatment. So that is the exception to the rule. So let's take a quick look at how that would play out. Once again, let's say that we have a findings and award stating that epidurals are absolutely necessary. But we have language in the MTUS contradicting the use of epidurals in this particular case. Well, if the carrier issues a UR denial and the IMR agrees, then the parties would go see an independent doctor. And so the parties go see an independent doctor, Dr. Jones, who recommends physical therapy instead. At that point in time, the parties could stipulate to go with physical therapy instead of the epidurals that were specified in the original award. What are our takeaways from SB 563? Well, this would have barred UR and final awards in most cases. And the reason why this bill was created was to ensure that applicants get care specified by the workers' compensation judge. One of the cons about this bill is that it would have required many new regulations by the DWC to monitor exceptions to the rule. And what I mean by that is I feel that the exceptions to the rule would require quite a few regs to tell us, for example, the time frames for the UR decision, the time frames for submitting this to IMR, how the parties go about selecting an independent doctor, and how the parties, and basically what the parties can and cannot do after the doctor issues his opinion. For example, what if the doctor punts? What if the doctor says something that angers both parties? Or what if the doctor says something that one party likes and the other party does not like? All that would have to be addressed by regs promulgated by the DWC, and that could take a while, and frankly, I anticipate the regs would probably leave some portion of the population unhappy. Now let's move on to another dead bill, Assembly Bill 511. What this bill would have done is it would have expanded the definition of the term peace officers. So for example, the term peace officers would have been expanded to include security officers, correctional officers, custodial assistants, and others. And so this bill would have increased exposure for cities and counties. For example, a security guard would be entitled to the same cancer and cardiology presumptions that a police officer enjoys. AB 511 died in committee, and Governor Brown has vetoed bills like this before. Now, in my previous experience covering all 50 states as a journalist, we frequently saw labor trying to expand the rights and protections of first responders year after year. Most governors in most states will tend to veto this unless there is a compelling reason. By compelling reason, I mean a case that draws quite a bit of media attention and, for example, is on the nightly news for several days in a row or up to a month. Something that flags that much attention could make a governor think differently about expanding the definition of peace officers and expanding protections for city workers. So what are our takeaways from AB 511? This would have expanded the definition of peace officers to include many others. would have likely been vetoed by the governor. I anticipate a similar bill coming out next year. And once Governor Brown leaves office, I expect them to test the new governor with a similar bill at that time. Let's take a look at Senate Bill 281. This is another bill that died early on. It actually died in committee. And this bill would have slashed the salaries of the Workers' Compensation Appeals Board commissioners. Currently, the average commissioner makes about $79,000, and the chair of the board makes about $82,000. What this bill would have done is it would have slashed the salaries of non-elected members of state boards down to $12,000 a year. Now, while this bill was aimed at reducing corruption for government appointees, it failed to recognize that our WCAB commissioners paged through thousands of recons and removals each year. It was a very difficult job. And in short, I feel that this bill failed to understand that we need superb Workers' Compensation Appeals Board commissioners. Our current commissioners are already being paid far less than they're worth. Why would we want to cut that down to $12,000? So our takeaways from SB 281, it would have slashed salaries down to $12,000 a year for the WCAB. It was aimed at reducing corruption, but it would have reduced the incentive for qualified lawyers to become a commissioner. And therefore, this bill died in committee. I hope we don't see a bill like this next year. Now let's move on to some of the regs that were let's take a look at some of the regs that were proposed by Senate Bill 863. Senate Bill 863 called for new regulations such as the home health care fee schedule, the interpreter fee schedule, and the copy service fee schedule. Now, I should point out that this is still being developed by the DWC, and the home health care fee schedule would be based on the fee schedules used by Medi-Cal and the Federal Office of Workers' Compensation Programs. Now, both labor and payers disagree with many terms in these regulations, and both sides are trying to influence the DWC's language in these regulations. The most recent public comment period was in May 2015, so a few months ago, and I believe that the DWC will likely issue a new proposal at some point in the next few months. Now, what would this proposed home health care schedule do? Basically, it would reimburse home health care providers based on a Medicare formula. And that formula is comprised of three facets. The first one is the type of work that is being done. The second one is the average cost of that work, and the average cost of malpractice. Now, each of these three elements is valued differently in that formula. In the past, many doctors have complained that reimbursements were too low under this Medicare formula. And I would like to give you a perfect example, but in short, the cost will vary by the types of services that are needed and who is providing them. So there is no easy example to give you as far as how much the average home health care worker would be reimbursed. Now, the California Applicants Attorney Association did weigh in on this, and in their comments, they wrote that they do not want home care to be subject to utilization review or IMR. Instead, they want home health care deemed authorized until there is a denial. Obviously, payers do not want that. The other thing that labor wants is they do not want home health care workers being subject to assessments that are documented in the CMS standards. And those standards are called OASIS. That's CMS's OASIS program. And what that program requires, as far as I understand, is that these home health care workers should be assessed before they start providing the care. Now, employers and carriers have also weighed in, and the first thing they said is that these regs should only apply to unskilled care, and that fees for registered nurses, licensed vocational nurses, and professionals should be addressed by the official medical fee schedule, which already exists. And that does make sense. We have the fee schedule, which is able to currently tell us how much RNs and LVNs should be paid. So, in short, I agree with that. These regs should only apply to unskilled care. Secondly, payers have said that these regs should require RFAs for all home health care services. And that, in turn, would allow carriers to perform utilization review on home health care. Lastly, payers want language stating that these home health care providers do not become the carrier's employee once they start providing the home health care. And the concern there is that should that home health care provider become injured while helping the applicant, we don't want to see the carriers see exponential liability for two people's claims all of a sudden. And as we know, healthcare is quite a dangerous business, and they do have quite a high XMOD. So that is a concern. We don't want to be taking on additional employees when we don't have to. Now let's move on to another fee schedule that was called for by Senate Bill 860. Also still being developed by the DWC. And this proposed fee schedule would set price caps for half days, full days, and hourly rates. Now, this proposed fee schedule received an unusually high level of comments from interpreters. If I remember correctly, there was about 253 pages of comments from interpreters, many of whom opposed the schedule in its entirety. Now, one of the key takeaways from this proposed fee schedule is that, as many of you know, we currently have a 2-hour minimum for a visit to a doctor's office, for example, that an interpreter can be reimbursed for. So while the current rate is $45 an hour, you multiply the $45 times 2 hours for the 2-hour minimum, and you come out to about $90 per date of service. That's why many payers do pay interpreters at a rate of $90 per date of service. Well, this proposed fee schedule would remove the 2-hour minimum, and it would increase the hourly rate to $52.50. So for example, if the interpreter helps the applicant go to physical therapy for half an hour, that would be reimbursed, the interpreter would be reimbursed at a rate of $52.50 rather than the $90 per date of service that many carriers pay at. So that could be a huge cost saver. One of the criticisms of this bill, or one of the criticisms of this interpreter fee schedule, that is that it does not include regulatory controls for multiple appearances. What I mean by that is that, as we all know, there's many interpreters who go to the Workers' Compensation Appeals Board, they bill 2 hours per case, and they work on 10 to 20 cases a day. We all know that these interpreters are not working 20 to 40 hours a day, but they're certainly billing for that. So that is one area that we feel that these regs could certainly address. Another criticism is that the regs in the interpreter fee schedule would currently allow for provisionally certified interpreters. And what does that mean? A provisionally certified interpreter is one who's deemed by a physician, judge, or payer as being capable of translating. And so some have weighed in with concerns about the quality of these interpreters and whether they might confuse terms that the injured worker is using, and may confuse important facts about the injured worker's injury. So there are concerns about provisionally certified interpreters. Now let's take a look at the caps proposed by this fee schedule. The most recent version of these regs would reimburse Spanish at a rate of $210 for a half day and $388 for a full day. Non-Spanish language interpreters would be reimbursed at a rate of $240 for a half day and $418 for a full day. Now, many of the Spanish language interpreters have argued that this is a discriminatory practice. Personally, I believe that the lower rate is likely based on a theory of supply and demand. In short, there's a much greater supply of Spanish interpreters than there are exotic interpreters out there. And thus, that is the reasoning for the slightly lower rate. And with that being said, it's not that much of a lower rate. And it's only $30 less for the full day, $30 less for the half day. Now let's take a look at the copy service fee schedule. As many of you know, this was approved by the DWC several months ago, and it applies to dates of service on or after July 1st, 2015. That being said, I can say from my personal experience, even though I've gone to trial on copy service lanes with dates of service before that date, obviously, and the trial judge has urged us to settle based on the copy service fee schedule. So this is a good negotiating tool, and some judges may even request that you use this in your negotiations. Now, what's the key term to this fee schedule? Think $180 for most services. What I mean by that is there's a flat fee of $180, and that covers records of 500 pages or less. Every page exceeding the 500-page threshold is worth 10 cents a page. Now, this fee schedule also states that copy service bills must include professional photocopier numbers, claim numbers, billing codes, and the provider's tax number. Now, if you want an extra copy, that's $5 if you request that within 30 days of the original subpoena. If you wait more than the 30 days to ask for that extra copy, the extra copy's reimbursement rate jumps up to $30. Now, absent showing of good cause, this copy service fee schedule states that payers are not liable for records previously obtained by subpoena or authorization by the same party and served from the same source. And so that's good because, as many of you know, we will see applicants' attorneys send out subpoenas to the same entity anywhere from 1 to 5 times. The fee schedule also reimburses DWC transcripts of 33 pages and less for a rate of $100. And if you're getting more than 33 pages of a DWC transcript, the reimbursement tacks on an extra $3 per page. Now, we have been contacted by risk managers out there and claims unit folks who have expressed confusion over the $15 fee that carriers and TPAs charge copy services. And what I mean by that is when, for those of you who don't know, when these copy services do go to the carrier and ask for records, it's customary for the carrier to charge these copy services a $15 fee. That fee is supposed to cover the time and expense that they spend collecting those records. Now, per the copy service fee schedule, claims managers may continue to charge the $15 fee per subpoena, but they can only do that when they are not a party to the subpoena's case title. So you cannot be a party if you're going to charge that $15 fee. And if you'd like to find out more about this, please check out that link below. I wrote a blog explaining how the copy service fee schedule and how the California Evidence Code support that particular conclusion. Now let's take a look at case law. Our biggest, most recent case is, of course, the Angelotti decision. And in this decision, the Ninth Circuit Court of Appeals, the federal court in Northern California, they upheld Senate Bill 863's lien activation fee. Now, what did Senate Bill 863 call for? This bill had required a $150 filing fee payment for new liens filed on or after January 1st, 2013. It also called for a $100 fee payment on any liens filed before January 1st, 2013. For all liens filed before January 1st, 2013, they had to pay the $100 fee to be activated by January 1st, 2014. Now, many lien claimants did not do this because they knew that there was going to be a constitutional challenge to the lien activation fee element of Senate Bill 863. So in other words, I believe tens of thousands, if not hundreds of thousands of lien claimants refused to pay that fee. Now, what did the Ninth Circuit do? They ruled in payers' favor, of course, and they upheld the lien activation fee by saying that it is constitutional. However, you have to keep in mind that the lien claimants did ask the Ninth Circuit for en banc review, which would require all of the Ninth Circuit justices to re-review the case. Now, this is extremely rare for the Ninth Circuit to grant en banc review, and many lawyers out there think that the Ninth Circuit will definitely deny the petition for en banc review. So if they do deny that, that would leave it up to the U.S. Supreme Court, who is also unlikely to grant review, as they grant review to less than 0.5% of their cases. You also want to keep in mind that lien claimants might continue to file new and different legal challenges to the lien activation fee. And this simply depends on how deep their pockets are. Now, if this should happen, this could leave the lien activation fee issue unresolved for quite some time. Now, shortly after the Angelotti decision, the WCAB admonished workers' compensation judges for dismissing liens for failing to pay the lien activation fee. And one of the reasons why they did admonish the judges is that the lower court, in other words, the superior court, must still technically invalidate its injunction. And once that's done, the DWC still has to activate its payment tool. They actually deactivated their online payment tool shortly after the injunction was granted back in 2013. So they need to set that up again. What is likely to happen next? Well, once the injunction is lifted, I believe that the DWC is likely to announce a grace period of 1 to 2 months. And so that grace period would allow lien claimants with a date of service before January 1st, 2014 to pay their lien activation fee. The DWC would likely clarify which lien dates of service have to pay which fee and when the deadline for that is. So what should you payers do in the meantime? Well, in short, I would wait for further direction from the Division of Workers' Compensation. I anticipate that they'll send something out in August, if not sooner. So, yeah, I'd say sometime in August. At the very latest, I'd be surprised if they wait until September to issue further direction on that. If the DWC does grant a 1-month extension, you'll have to wait that month before you can use the failure to pay the lien activation fee argument for dismissal of liens. Let's also take a look at some issues that the California District Courts of Appeal will consider coming up. In the next few months, they're going to consider multiple due process challenges to utilization review and IMR. The appellate courts will also consider apportionment to genetic predisposition. In that particular case, the applicant's father's medical history showed degenerative disc disease, and in that case, the MedLegal, I believe it was a QME, had apportioned to the applicant's genetic predisposition for having degenerative disc disease. Now, I have seen some panel decisions out there saying that it is unlawful to apportion to that. Another issue that the District Courts of Appeal will take on is whether the WCAB had jurisdiction to apportion a basketball player's cumulative trauma claim solely to the New York Knicks basketball team. Also looking ahead, the appellate courts will also consider questions about whether a applicant is entitled to 100% PD based on a AME's opinion that the applicant can only work from home. And that sounds like a pretty interesting case. I'll be looking forward to that one. They will also take a look at whether a workers' compensation judge should have first considered an applicant's CalPERS death benefit before awarding a workers' compensation death benefit. And that's a case that many of you cities and counties will want to keep an eye on as well. And also recently, we had the California Supreme Court issue an opinion in the South Coast framing case. That came out on May 28, 2015. Now, in that ruling, the state Supreme Court ruled that the applicant's family was entitled to death benefits after the applicant had overdosed from a combo of industrial and non-industrial drugs. In that ruling, the High Court said that the correct causation standard, in other words, the correct standard for the court to consider, was the work injury a contributing cause of the applicant's death? Now that differed from the lower court's question that they had asked. The lower court had focused on the terms material or significant role. In other words, the lower court had asked, did the work injury play a material or significant role in contributing to applicant's death? And as you can see, the High Court's standard is a little easier for applicants to satisfy than the lower court standard. Now, personally, we would have liked to have seen the state Supreme Court address the Labor Code's use of the term proximate as the High Court evaluated the causation of injury standards. Unfortunately, the state Supreme Court did not do that. If the High Court had addressed that point, that could affect how judges view whether a workers' compensation carrier could be liable for a death that is arguably non-industrial. And with all that being said, we've reached the end of our slides here. But thank you so much